Stock options and phantom equity plans are often seen as attractive ways to reward employees without upfront cash. But what many business owners miss is the legal complexity that comes with delayed compensation. Once you promise future payouts tied to performance, you step into ERISA law, a federal law that regulates how and when these rewards can be offered. What starts as a simple bonus plan can quickly turn into a legal burden with compliance requirements and unintended consequences. Another type of contract that business owners often think about is stock options, a phantom stock plan, or some sort of stock incentives. I'm not going to go too deep into this. I have a whole video that talks about these options on my YouTube channel, and you can see a link to that in the information below. But let's just talk about what these are. Basically, you are promising that employees will not just get immediate payment for their services. You're promising they might get something down the road. If the company does well, you'll get something. So maybe that's some sort of stocks or shares in the company. Maybe it's a phantom stock plan, which is another type. It's basically a contract with bonus payments. But here's the thing you should know about. Often when you get into delayed compensation like that, you run into ERISA law. ERISA. It's a federal statute that protects employees in scenarios where compensation is delayed. Because what often happens is employees agree, hey, that sounds like a good deal. I could get really, really rich. I heard about how Facebook founders or Apple founders or early employees got a lot of money. And the concern was business owners could kind of dangle these rewards or these carrots in front of the employees saying, hey, you might get something amazing down the road, stock options or some sort of financial reward. But then the employees are basically stuck in the company. They can never leave because if they do, they'll lose whatever that thing was. So Congress decided we're going to put some limits on what can be done here so that there's some fairness, some transparency. That's part of ERISA law. So most small businesses find it's actually not useful to use future incentive pay to reward employees for a couple reasons. One, because of ERISA law and the fact that you need to make sure whatever plan you put together is compliant with ERISA law. Second, there are some much easier alternatives. When you look at best practices for motivating and incentivizing employees, there are some great books and studies that have been done over the last couple decades. And what they have found is this idea of enticing employees with speculative, huge payouts down the road rarely is effective and actually can cause stress on employees. So that's something you can explore further on YouTube or in your research. But from a legal standpoint, usually employee stock option plans, phantom stock plans, and similar incentives end up being more legal expense than it's worth. Now, if you'd like to know more about how to avoid trouble like this, I have a free resource at aaronhall.com/free. I provide information for business owners of small to mid-sized companies on how to avoid common legal problems. That includes a PDF. It includes videos talking about important issues. I'm Aaron Hall. I'm an attorney for business owners and entrepreneurial companies. If you'd like, subscribe to this channel so you can get more educational content like this.